Alright guys, okay, so I'm going to try and make this as quickly as possible because I only have 10 minutes. So people were telling me about the Constitution Act and Section 32 and 52 about how they were trying to use it in the law or in the courts, and they were just brushing it off. So I'm going to help you try and reinforce that position even more. We got a lot to cover in 10 minutes, so that's awesome ass. So first of all, so this is the Constitution Act, which is the Charter of Rights and Freedoms. So if we go to Section 32, okay, it says right here, it says that the application of the Charter. So the application of the Charter says Parliament to go and Government of Canada and the legislating government of each province. So now that we got that taken care of, Section 52 is the supreme law, so pretty much saying if anything's inconsistent, it's null and void to that extent. So Law Society of Upper Canada. Law Society of Upper Canada is the thing that's responsible for all bar members, which is lawyers. So if you go to the Law Society of Upper Canada and you type in charter claims, you'll get this page right away. So well, I want to bring your attention to this, Section B. So we go to Section B. It says Charter applies to government action. We'll take care of action in a minute there. So, but obviously, as you can see, it says read Section 32 of the Charter. The Charter applies to the actions of the federal government and to the provincial governments only. So it only applies to them. So now they've got that taken care of. All right, so let's just nail this. Let's nail this shit down too. So this is what I got this from the words and phrases. It's a book that you can get. It's a legal dictionary that you can get from the law libraries that's in your city. Ottawa has it because that's where I got it. When you look up on government function, this is what it says. I want to bring your attention to this section right here. 1 second. What the fuck is it? It says, in my view, the government function, government control, state action, or nexus which links the essential private university with the province is insufficient to invoke Section 32. This is an excerpt from the case where it says McKinney v. University of Guelph. So pretty much what this is saying is that unless you're engaging in a government function or government control, state action, which government action, or a nexus, you don't qualify under the Charter. So unless you're doing those, the Charter does not apply to you. So let's nail this one. So if you look at government action in the same book, which is I think is just on the left side of the page there, and you look up on that, it'll actually tell you to look up on laws. When you look up on laws, this is what you get. Supreme Court of Canada, while I do not dispute that law is not confined merely to legislative actions, legislative activity, I am of the view that the element of coercion must be present even in government activity or program for such to be reasonably characterized as law. So what that is pretty much saying is if you're not engaging in a government activity or a government program, you are not under the law. Not above the law, you're just outside of the law. Okay, so government activity and program. Program is function. Activity is action. So if you're engaging in a government activity such as performing a duty that's under an act, such as a police officer or anything such as that, then you will be engaging in government activity. If you're engaging in a government program, then you must be then the Crown must be finding evidence or proof that you are actually implementing a public policy or public program. Most of the time, most of us people, we're not doing that. So when you claim that your constitutional rights has been violated, it's kind of a little bit like fraud. Okay, because it only applies to a specific group and you ain't a part of it, so you're not part of the club. So again, this is constitutional law, and you can look up on Douglas Quantley faculty v. Douglas College. That's the case that this excerpt was from. So now that we got that taken care of, oopsies. This is another nail in the coffin, right? So you know how the Charter was put in on April 17th, 1982. This judgment or this ruling was made on the 9th of May, 1983. So it's a little bit, the Charter was a little bit older than a year when this ruling was laid down. But the main paragraph I want to bring your attention to is this one. This is section 52 and 32 right there. That's what we're looking for, right? So it says Canadian Charter of Rights, freedoms, his municipal bylaws are subject to the Charter. Okay, so Section 52 declares the Constitution of Canada, which includes the Charter, is supreme over any law that is inconsistent with it. The term law is meant to encompass every type of law that regulates people's lives. Hence, it includes statute law, common law, regulations, and any other binding legal norms, including municipal bylaws. Okay, so if you get fined and you're not under the Charter, you can send it back for lack of cause of action because, well, obviously you're not under the Charter. Charter reigns supreme. Charter only applies to government legislative authorities and provincial governments, so therefore you cannot be fined. Now, unless you have a contract or a binding agreement that says that you are part of it, such as Ontario Works or something about implementing public policy, then you will be under that. But otherwise, no, you're not. Another thing I want you guys to look at is right here. It says municipalities, though a distinct level of government for some purposes, have no constitutional status. They are merely creatures of the law, or creatures of the legislator, with no existence independent of the legislator or government of the province. Hence, just as provincial legislators and governments are bound by the Charter, so too are municipalities, whose bylaws and other actions must be considered for the purpose of Section 32 as actions of the provincial government which gave them birth. So pretty much what that's saying is municipal governments are subject to the authority of the provincial governments. And as what this paragraph has said, federal and provincial governments are also subject to the Charter. So therefore, municipals are subject to the Charter. So now that we got that taken care of, right? Which is here's a little tidbit of information extra there. It says the Heritage Canada website says the purpose of the section is to make it clear that the Charter only applies to government and not to private individuals, businesses, or other organizations. Holy fucking shit! Would you look at that? So now, see, I used this like today's Saturday, right? I think it's the 6th, yeah. September 6th, 2014. I used this just yesterday on Friday. We were going for a pre-trial hearing for one of my buddies there, and I used these arguments, and 2-3 hours there, all the charges were withdrawn. My buddy was facing assault on a police officer, and he actually had firearms, which is fucking nuts. And according to the disposition, which I read just for shits and giggles, discovery, apparently my friend was trying to fire shots against a police officer. So that was some pretty crazy shit. So now I want to bring your attention to the something else, a little bit more provincial, but still pretty much hammers it right down now. Now I'm gonna give credit this to Scott Duncan because he helped me out with this stuff there. He released his version, but this is pretty much my understanding. When I say my understanding, meaning my abridged version or whatever, this still does the job. So I only put in the necessary things because obviously you have to tailor it to your situation. So you put in a notice of mistake and says right here, it says, take notice that I, in the matter of surety for case file, whatever, for the legal name, and I believe that there's a mistake in identifying the sole beneficiary of a public document. So pretty much what you're saying is, like, by what authority do you have to attach me to a name that's derived from the public document, right? Because you got the Change of Name Act, Section 2, Subsection 1B2, where it specifically states, for the purpose of Ontario laws, every person has entitlement to be recognized by a name that is on the birth certificate. That's what my quo warranto means. So quo warranto means by what authority. So you're pretty much telling them that you're waiving the public benefits and that you're taking their offer and you're returning it for declined and for immediate discharge and closure and stuff like that. So same thing with notice of public waiver of benefits. You're just pretty much making it more formal. Obviously, it says Ontario Change of Name Act. You're pretty much putting them on notice that you're waiving the public benefits. So yeah, so that's pretty much it. My buddy was facing federal and provincial charges, and he got all of the charges, federal and provincial, all withdrawn within a few hours of dealing with this. So